Good afternoon, everyone. Thanks for joining for the Running Secure, Understanding the Secure Act. I have just a few announcements. For those of you who are requesting credit, please note that to receive CE credit, you must remain logged in to the video portion of the webinar for the entire program. Logging into the audio portion only is not sufficient for CE credit. Continuing education credits are being offered for the following designations: CFP, CIMA, CPWA, CIMC, RMA, and SHRM. Also, at the end of the webinar, we would like to request that all attendees fill out the evaluation form that will pop up. If you have any questions during the presentation, please submit them through the question box. At the end of the webinar, we'll answer as many questions as we can, but we want to be respectful of your schedule and end on time. If we don't get to your question today, we will definitely follow up with you afterwards. Tomorrow, you will receive an email with a link to replay today's broadcast. Let's get started. We are joined today by Rich Rouser, Senior Vice President of Thought Leadership at Pentegra. Rich has more than 30 years of experience in the retirement benefits industry and is responsible for helping to shape and define Pentegra's viewpoint on workplace retirement plans, plan design strategy, and retirement success and employee saving trends. Rich, let's talk the Secure Act.
All right. Thank you, Lizzie. Thanks, everybody, for attending the session this afternoon. I think it'll be pretty engaging. We're going to cover a lot of the topics that were presented to us in the Secure Act when it was passed a couple of years ago, and I'm going to filter in a number of things as we go through this today. I'm going to filter in some observations. I'm going to talk about some of the proposed legislation that's out there that could end up changing some of what was written originally in the Secure Act. And some of those changes either broaden the scope of what was intended by Secure or simply refine it. There's also some proposed rules out from the Department of Labor that if they all go through in the proposed format, will impact 5500 reporting, for example, on PEPs, pooled employer plans, and that DOL initiative also would impact GOPs, the group of plans. They're now called DCGs, defined contribution groups. So, and I think the biggie in the DOL proposal is changing the audit requirements for qualified plans, which is kind of interesting. So I'm hoping we have enough time today to go through all those pieces and features and give you a really good understanding of where things are today. So we'll start right into it. So the Secure Act was passed back in December of 2019 under the prior administration, and it really is kind of a wish list of everything, pretty much everything that we've wanted in the retirement plan industry for the last decade or so. PEPs, were certainly one of the big highlights, pooled employer plans, right, of the Secure Act. And our firm, as well as a number of other firms about 8 years ago, kind of tested the waters pre-PEP, with things called open MEPs. And, we had even gone as far as launching a number of those. And then the Department of Labor came out with a couple of, I'll call them adverse advisory rulings, basically not recognizing the concept of an open MEP. But all we had to do is hold our breath for about 8 years, and the laws kind of came around to spawn the concept of an open MEP, which is really what a PEP is all about. So it was kind of cool, but it took a while for us to get there. So we'll go through. We're going to go through kind of this in two pieces. One section, which I'm going to jump to first, when you see the PowerPoint, when we send it to you later on, I'm really starting at slide 21 for today's presentation, and then I'll go back and jump into the ordering of the first section. So the first section was laid out with more wealth management type concepts, which certainly are relevant, but I thought for this group, just looking at the audience who's attending today, that we would start with the retirement plan concepts first and then get into the wealth management as a second part. So Section 101 is really what created PEPs and basically the concept of unrelated employers participating in a single retirement plan. And PEPs are really a subset of MEPs, which are multiple employer plans. And multiple employer plans, or MEPs, have been around for decades, literally decades. So a lot of the groundwork of how a PEP works was already established, in the MEP environment. And, the key differences between the two: a MEP is really a group of related employers, not necessarily, certainly not control groups or affiliated service groups, but related, could be by industry. The terminology we use is there's got to be a common nexus that joins those employers together. So the rules for a PEP pretty much mirror MEPs, including, I came out of slideshow mode for some reason, including something called the shared service rule, which is always interesting in the MEP or PEP environment. And the shared service rule is a pretty simple concept. It's, if I work for employer A, who's an adopting employer in either the PEP or the MEP, and as an employee, if I move from employer A to employer H, right, whatever that one is, employer H, their plan under that PEP or MEP has to recognize my prior service with the other adopting employer in that PEP or MEP for purposes of vesting and eligibility, right? So if, the other plan that I joined as an individual would have a 1-year waiting requirement, and the plan I came from only had a 6-month requirement, and if I was eligible under the other plan, basically my eligibility is going to continue, right? It's kind of a concept of once eligible, always eligible, but even more to the point is the vesting concept. If I've got a couple of years of service with the first employer, and I now go to that second one who's also part of that same MEP or PEP, I kind of start right there. I've got 2 years in the bag already, and I progress up the scale. So it's one of those, I'll call it administrative issues, challenges, record keeping, if you will. So the one thing I always talk to plan sponsors about is the fact that they need to be aware of it is step one. But number two, it's really incumbent upon, I think, the record keeper primarily, and ultimately in a PEP, the pool plan provider. We'll get into that a little bit later. But to be aware of it and make sure that the plan is administered properly. So, the one thing I see in the PEP marketplace is there are folks kind of creating PEPs out there who don't necessarily have a lot of experience, right, running a MEP, and don't necessarily, they're not totally fluent in how they work. So it's just one of those things that you have to be aware of, and that clients should be aware of if they were to join a MEP or a PEP. Just again, real high level, what's the point of a PEP or a MEP? The real driver by the current administration, the prior administration, and obviously of the Secure Act is to broaden retirement plan coverage in the United States and make it easy or easier for employers to sponsor a qualified 401k plan and enable participants to join into that arrangement more readily. And the biggest pros, so to speak, from a client perspective is they're outsourcing fiduciary governance, and they're really handing the administrative aspects of the plan as well as the governance aspects of the plan over to a professional, right? The pooled plan provider who is the principal fiduciary responsible for running the plan properly. So, a big thing in the two administrations as well as DOL positions on PEPs is they should be a, high quality, low cost, quote unquote, low cost solution. And the one thing I'll always say about a PEP or a MEP is that, and by the way, that statement is true, generally going to be true as long as that MEP or PEP has sufficient scale. And by scale, I mean it's got a bunch of adopting employers, it's got a bunch of eligible participants, it's ultimately going to have a bunch of money in it. So, from my standpoint, a PEP or a MEP has a high probability of success in terms of driving costs lower if, that PEP or MEP ultimately has $50 million or more in plan assets. The only real risk or danger I see in terms of a PEP or a MEP is if one is created and, it only has 5 or 10 or 20 employers, adopting employers, and only maybe a couple of hundred eligible plan participants. I having decades of experience at our firm in terms of running MEPs, a smaller arrangement it's going to be very hard to bring it in at a lower cost. But again, once scale is achieved, the low cost metric can certainly come into play. And again, if you think about the logic behind that, right, there's a couple of components to running a PEP. One is you need a pool plan provider, right, which is stepping into the shoes of the fiduciary for the program and the plan, and is ultimately responsible for properly running that program and that plan. Most small employers don't outsource fiduciary responsibility in any way, shape, or form, and they retain that responsibility. So, there's an additional service provider at the helm here, so to speak, and there's got to be compensation for that service provider. Other areas of cost and expense in running a group plan like that is, the record keeping aspect of it. And, certainly when you band employers together in one group, even though they have different plan provisions, you get a little bit of savings, I think, out of record keeping solutions, but not a ton. It's not like you can cut those costs in half. Those costs of record keeping have been driven down and down and down over the years, and not a ton of room there. But nonetheless, a PEP or a MEP or a DCG, which we didn't speak about yet, we'll talk about that in a few more minutes, definitely can be a good solution for a lot of clients, and there's a couple of different strategies in putting those together. So that, I think, was a really key section of the Secure Act. So, and by the way, this is not going to go in strict order of the various sections of the Secure Act, but Section 104 of the Act basically increased tax credits available to small employers. And these numbers are substantial, and these tax credits are designed. I'm not going to go into all the complexities of how it works today, and truthfully, it's not all that complex. There's an IRS form that the employer would fill out and check the boxes, and it notes how many eligible participants the plan has, so on and so forth, and it basically sets up tax credits to enable that employer to launch that plan and offset or pay in full for a lot of the startup costs that might be involved in launching that plan. So, and by and large, a tax credit is generally going to be much more valuable to a tax-paying entity than a tax deduction. They still get tax deductions, obviously, for contributions they make to the plan, but tax credit is really just dollar for dollar flows through to the business sponsoring the plan. So, if you're advising clients on new plan formation, this is not to be overlooked. It's pretty significant in terms of a means of offsetting costs of starting up a plan. Section 105, again, it's kind of an extension of the tax credits. This is for plans that also are forming that new arrangement and have auto enrollment or a simple plan feature in the plan structure. So again, an additional tax credit that can be applied or gained or garnered by the employer who's adopting that plan or that program. Now, one question we got on this is, how does it actually work? What if I started my plan a year or two ago, and now I'm joining a MEP or a PEP? Am I still eligible to get that tax credit? And the answer is yes. Just because you're changing the structure, and I think these tax credits can run over a period of 3 years of time. So the answer is yeah, you can still get it, and you're not jeopardizing that just because you're changing the structure a year or two into it. Here's another thing, and by the way, I said at the onset today, what's the point of almost everything or a lot of the things that are in the Secure Act? It's increased plan coverage, increased participation rates among the participants, and basically to help transition, right, due to the demise of defined benefit plans over the last 3 decades. fewer and fewer participants have any defined benefit plan coverage at all, and all of that burden and risk of investing has been shifting to the participant level for decades now. So one aspect of Secure is to increase the auto escalation cap from a cap of 10% to 15%. And auto escalation, if you haven't been involved with that before, basically can be coupled with automatic enrollment, right, where you can default auto enrollment to typically a minimum of 3% or a max of 6% of pay contribution, right, kind of get participants to automatically defer at a good rate, decent rate. But then the auto escalation feature increases that savings rate by typically 1 or 2 percentage points year by year by year. And under the old provisions for auto escalation, there was a cap of 10% of pay. So Secure Act increases that cap to 15% of pay. And just, in our view, our opinion, 15% of pay is the right number to be saving long-term for the typical employee in a 401k type plan. And, when I thumbnail that 15% number, certainly if they can do more, that's great, right? But the reality is a lot of participants are not going to go much above that 15% level. But the 15%, I also look at that as kind of a combination of not only the employee's salary deferral, but counting the employer matching contribution, if any, counting, let's say, the employer's profit sharing contribution, if any. So, if an employer plan sponsor were matching, let's say, 50 cents on the first, or 50% of the first 6% of pay, that's 3% there. So, I like the 15% as a bogey. I do count employer and employee contributions towards that number. And again, it's just a rule of thumb, as we all know. But again, for the typical employee who's going to be in for a couple of decades, 15% in my mind really is the right number. So auto escalation helps participants get there over a period of time. So we certainly welcomed the increase in the auto escalation cap. This is Section 103. And by the way, most of these provisions, many of the provisions are effective for plan years beginning in 2020. Again, the legislation was passed in December of 2019. And there are some sections that are not effective into year 2020, right? So some are effective really as far out as 2024. And a couple of features were actually retro to 2018, believe it or not. But this is one that tends to take some burden off of the administrative aspect of the plan. Certain 401k notices and safe harbor amendments are liberalized, meaning you don't necessarily have to send certain notices. So we won't go into all the detail on that today, and that's really more for whoever is a fiduciary of the plan, right? Because they're ultimately responsible, right? The ERISA 316 fiduciary is typically going to be responsible for making sure participants get the appropriate notices. So this was under the heading of simplifying things a little bit. We're still not totally where we need to be in terms of simplification of employee notices. There's definitely some proposed legislation out there. Whether I can't remember specifically if it was in Secure 2.0 or the RISE Act or one of those, or maybe both of those, that would further reduce, kind of the paperwork and also streamline some of it into electronic disclosures as opposed to constantly sending paper out the door. So this was a welcome feature, and I think it's beneficial in terms. And again, this is something that can help drive costs down over the long run, with one less administrative task to take care of in terms of managing and running the plan properly. Section 201. Right. So this is retirement plans may be established after the due date. So let me give you a couple of examples here. So you can establish. A good example is we're now in February, almost March of 2022. And a lot of companies are in the process of doing their corporate tax returns or LLC or LLP tax returns for 2021. So a lot of times, and we see this more with smaller plan employers, where holy cow, the business is really doing well. Cash flow is great. Cash flow is expected to be great going forward. Gee, we wish we could have put a plan in for 2021 for last year. So this allows you to do that, right? You can actually retroactively adopt a plan retroactive to the beginning of 2021, beginning of last year, and you can do that as late as the extended tax filing date for that organization, right? So for a regular corporation, tax filings are due at the corporate level March 15th. They can typically apply for up to a 6-month extension, takes you out to September 15th. For certain partnership structures and others, individuals for that matter, the extended tax filing deadline is as late as October 15th of this year. So what this has done for service providers as well as plan sponsors, well, for plan sponsors, the benefit is clear. If there was a huge tax advantage and benefit of me adopting a plan for last year, I still have an opportunity to do that for 2022. So if you're advising clients, this is a great opportunity to have them look at their cash flows and profitability and so on and so forth, and maybe make a recommendation to do a DB plan for last year. We see a lot of employers who want to adopt a cash balance type of plan, for example, is the best example I have, and do it retro to last year. And we typically see those structured in conjunction, with a 401k plan. Now, I want to slow myself down a little bit, right? If you think about, can I adopt a 401k for last year? Well, the answer is, in theory, yes. Can you really defer into it? The answer is no, because you've already earned the income and whatnot on, at the participant level, right, for last year. But you could certainly adopt a profit sharing feature for last year in a plan newly established for last year, even though you're adopting it this year. But certainly a DV-DC combo type plan could be partly put together for last year and certainly in full force for all of this year. And again, you can do that on a retroactive basis, which is kind of cool. We used to go through the year-end challenge and for certain sources of plans that would come into us, we would do a cutoff like December 22nd or something like that of each year to say, hey, we really need your signed, sealed, and delivered adoption agreement for any plan that's going to be in place before the close of that calendar year. Otherwise, we just can't process all the paperwork and do everything and get it all set up. But now that year-end crush is over. But I think what's been a little bit, I don't want to say lost, but a little bit, and maybe it's not overlooked. Maybe it's just my perception. It's like, we should be talking to all of our sources of business, right, about, hey, do you have clients, potential plan sponsors where it may make sense to retroactively adopt a plan for last year and get, in some cases, some pretty big tax deductible advantages for last year, even at this late date. So, and by the way, it's not late until that tax return due date or the extended due date of that return. So I think that's really a good planning tip to remind your sources of business of this feature. Oops, let me try to get to the next slide. Okay. One more try to get to, there we go. Okay, Section 112 of the Secure Act applies to planners beginning after 2020. That means this year. And you can see, I call this LTPT, the long-term part-time. In this slide, we call it long service part-time employees. And basically what the Secure Act is trying to address is, those part-time employees who have been with a company year after year after year, but never quite met the eligibility requirements. The plan might have had a 1-year, 1,000-hour requirement to become eligible for the plan. So what this section basically says, if that long service part-time person has 3 years of more than 500 but less than 1,000 hours, they could become eligible for for participation in the plan. And the way this works is, you can see from the heading of the slide, begins in 2021. So essentially what we do is start counting 21, 22, and 23. If in those 3 years they meet these requirements, that long-term part-time person would become eligible in 2024 plan year. So this is one of those things where it's important to, let plan sponsors know that they really need to be tracking hours worked, in particular for people who wouldn't otherwise qualify for eligibility in their plan. Because it's easier, obviously to start thinking about tracking those hours now, 2021 is year one of the count. Easier to track it now than 3 years from now. Say, hey, how many hours did each of these people work? And they'd have to dig through their records and everything else. And to me, it would make it potentially a much harder task to kind of get all the relevant data together. So, it's just one of those noteworthy points that talk to plan sponsors, let them know that this is something they need to think about if they have a bunch of those employees in this category. And by the way, this is a section of the Secure Act. There are some proposals to change this to a 2-year rule as opposed to a 3-year rule. And, we'll see if and when that change occurs, but potentially it could be just changing to a somewhat shorter period of time. Okay. Section 108 of the Act applies to certain loans, and the real takeaway here is loans can't be made via credit cards or debit cards or features like that. There were a number of record keepers in the industry who were offering basically a credit card to participants to enable them to take plan loans. And essentially, this is really just shutting that down. They were kind of issuing a card similar to what some HSA providers give participants for, HSA qualified medical expenses, right? So, but here it was actually going to be deemed to be a plan loan. So they shut that down. By and large, we tend to try to discourage plan loans. Plan loans, obviously, we know eats into the total retirement balances you can ultimately have in a retirement plan, and we tend to discourage them or try to have participants realize that a lot of times they think a loan is like, oh, I can just take a loan and it doesn't have any real negative impact on me, and they're not really understanding the opportunity cost potentially involved in taking a plan loan. So closing this down, I think, is not a bad thing, and it really was done, I think, in the best interest of plan participants. Now, with that said, just another viewpoint is, with a 401k plan, my view is typically it's a good idea to have plan loans. When we consult with clients and others on this, we tend to advise, offer the loan feature, put some restrictions on it. You can do something like $1,000 minimum. Obviously, the law, got out of slideshow mode for some reason. Obviously, the law caps that at $50,000, except for the CARES Act, which I'm not really going to talk about today. But the CARES Act doubled it temporarily. But the point of it is, make it $1,000 minimum. It shouldn't, loans shouldn't really be, in my view, used to, hey, let's go on vacation or buy holiday gifts or things of that nature, right? You shouldn't really take a loan out of your retirement plan to, for that kind of purpose. Is probably a better source. Keep coming out of slideshow mode here for some reason. There we go. Anyway, so this kind of crackdown on that, shut that down is the point. Okay. Okay, so Section 204 is talking about fiduciary protections, right? If there's a retirement income product, basically call it an insured annuity type provider to make payments. The big drive over the last couple of years has been to try to focus, I don't think we're there yet, but try to focus on how do we provide lifetime income solutions in qualified plans. And, we were interviewed by the DOL, I think it was probably about 5 years ago. And one of the questions they asked me is, gee, Rich, why are plan sponsors reluctant to put, retirement income annuity options inside their defined contribution or 401k plan? And I said, candidly, I think they're primarily afraid of two things. Number one, most plan sponsors are not necessarily well versed in insurance type products, annuities in particular, right? They may be more well versed in the concept of mutual funds or some of the typical underlying investments available in 401k. But once you start to dip your toe into the world of insurance contracts and annuities, that game changes. I don't know why this is flipping out of mode here. Let me get it back into slideshow mode. There we go. So they're not well versed, right? And they were reluctant. And if you think about an annuity, let's say I'm a plan sponsor and I have decided that the XYZ insurance company annuity is a great solution to have in my retirement plan. Keep in mind, annuities are essentially super long-term arrangements. Once a participant invests in an annuity, an insured product like that, it's not like you can just liquidate it and move it to a different fund. At least most of the products we've seen are not structured in that. I'm having trouble here with the slideshow mode. They're not structured in that manner. Is the point? Yeah, that's good. Hey, Beth or Lizzie, am I still connected to the audio?
Yeah, I can still hear you okay.
All right, you probably can't see the slides though, right?
We can see the slide, but cannot see. We can see it in slideshow mode.
All right.
And to make it a little bigger, Rich, you might want to just slide down the notes section so the screen is bigger, the slide is bigger for the audience to view straight from the mode you're in now.
Yeah. So my function on my computer has let me down here. So I'm no longer in the presentation, which is not a good thing. So I'm going to try to get back in here in a second or two. All right. Bear with me. It's going to take me a minute to get back in. It booted me out. Bear with me.
While we're waiting, if anyone has any questions thus far, please feel free to type them into the question box that's on your control panel, and we'll make sure if we don't get to them today by the end of the webinar, we'll definitely follow up with you. But now would be a good time to submit any questions you have.
All right, I'm still reconnecting. I apologize. All right. So, all right, I have a blank screen. So, Beth or Lizzie, can you just point me to the next slide, or I forget which slide number we were on the. So we were probably around the original deck slide. 28 or 29 or 30 or somewhere around there, right after the credit card loans.
Right. You know what, Rich, let's try one thing. We're going to, I'm going to see if I'll make Lizzie the presenter and let her share the slides, and you can talk through it while she's sharing. So just bear with us one moment here while we change presenters.
I'm still getting back into the system here.
Right.
So I'll tell you what, while we're waiting to reload the slides, I can talk about a couple of other provisions that I think are noteworthy. And let me spend a minute or two on the Department of Labor proposed rules on 5500s, which are going to impact, assuming they go through, they're going to impact, I think, to a positive degree, PEPs and MEPs for that matter. And, one of the things they said on audits, two things they said in particular. Number one, they're thinking of changing the threshold for an audit from the old rule, or the existing rule, I should say, is once a plan has more than 100, generally speaking, more than 100 eligible participants, an audit is required for the plan. What they're changing or thinking of changing, right, is the rule to say that it's got to be more than 100 eligible with an account balance. And, there's always the classic example of, the 250 life 401k plan that, who knows what, for whatever reason, in the first year of operation, they had 250 eligible, but gee, there were only 67 at year end with account balances. And from an employer standpoint, I only have 60, far less than 100 with accounts. Why do I need an audit of the plan? So the answer is the DOL is proposing to change that rule to say, hey, it's got to be more than 100 with account balances. So that would cut down on the number of audits required. It would, I think, certainly, eliminate a lot of the confusion that some plan sponsors have today in terms of how that head count actually works. So the other interesting thing that I think the Department of Labor came out with is with respect to GOPs, right, group of plans, which is another section of the Secure Act, which is on one of the slides that we're going to get back here in a minute, that basically allows groups of unrelated employers to file a single 5500. So you might say, well, wait a second, why should a GOP or a DCG, by the way, Department of Labor wants to call GOPs DCGs, which are defined contribution groups. Kind of sounds like the way a PEP works, right? 5500 for all the adopting employers. Well, the real difference here is the DCG or the GOP, so to speak. They're unrelated employers. Those unrelated employers maintain their own separate plans. So number one, it's not considered, right? It's not considered to be a single plan anymore. But they can do a consolidated 5500 filing, which is kind of interesting. Now, in terms of the audit requirement for a GOP or a DCG, by the way, GOPs and DCGs are effective this year in 2021. The interesting thing there is they did put an audit requirement into the DCG, and it's not a typical employee benefit plan audit. What's happened is they're saying there's got to be a trust audit. So, to kind of simplify, well, what does that really mean? Well, we know that employee benefit plan audits typically, probe each of the adopting employers and look at definitions of comp and make sure that all the, mechanics of salary deferrals and matching contributions and so on and so forth, are done properly and all that. So a trust audit is not going to go that far. It's really, I think, going to be much more like at least this is what the accountants have told me in the industry, much more like the type of audit they do on a collective investment trust, right, where they're looking at the cash flows in and out and market value, so on and so forth. So, I think that audit parameter is going to be much simplified. Now, the other thing that trying to get into my slides again. The other thing they said is that each individual plan in a defined contribution group is still going to have a separate audit requirement, right? So if you have a DCG or a GOP that has 25 adopting employers, and if they're all under the 100 life threshold, as I mentioned a minute ago, that threshold would be changed to be 100 with account balances, right? So basically, you can have a GOP with hundreds and hundreds of adopting employers, and if they're all smaller ones, there'd be no audit requirement at all. What's the real difference between a GOP and a PEP? Well, the audit requirement on a PEP, they had altered that to be 1,000 or more eligible participants, or any one employer with more than 100, would have the audit requirement in a PEP or a MEP for that matter. But here, it's definitely going to be different. And different folks in the industry kind of look at that a couple of different ways. Some people say, well, that's a detriment. Why would you ever do a GOP or a defined contribution group? And I think the answer is because it may make sense, right? It may make more sense to do it that way. Each of those adopting employers may, in fact, have more independent control over their specific plan because their individual plan doesn't go away. So what are the other requirements of the DCG? Well, the other requirements are, there are 5 or 6 things you have to have in common. All of those GOPs or DCGs have to have the same plan year. So most of them are going to be calendar year plans anyway. So that one is probably one of the easier ones to think about, right? But in a DCG or a GOP, you also have to have the same trustee. You also have to have the same investment lineup offered across the board to each of those adopting, each of those employers that are part of the arrangement. So, and that's interesting, right? Because GOPs got to have the same investments. In PEPs, you don't necessarily have to have the same investments. In theory, you could have different investments in a PEP, employer by employer. I think as a practical matter, though, you're not really going to do that because I think that's going to add to, the expense of the plan, is the expense of running the plan, the expense of running the audit in the plan, and all of that. So I think it's interesting. I think time will tell in terms of exactly how that's going to map out. So give me one more second. Lizzie, I'm going to need you to drive the slides. But let me just let me just open up my slides on my desktop here. Be there in a minute. Okay.
Richard, I think we were on slide 29.
Okay. I'm going to, my system is moving very slow here for some reason. So I'm almost there. All right. Okay. All right, Beth, the heading on that slide is what?
We're on 204, Retirement Income Provider Selection Safe Harbor. Amendment number 204.
Boy. Yep, I got it. Okay, so this is the one we were talking about kind of a minute ago. So the DOL, right, is, I shouldn't say the DOL. What's happened here with Secure Act is they put a provision in that essentially is protecting plan sponsors by putting an annuity lifetime income solution within the plan. And as I was talking earlier, right, that was one of the things the DOL was asking, sponsors don't want to do that. And I asked if they say it is too risky to do it from a fiduciary standpoint. Because again, there's annuity contracts or long-term agreements, and what if the status of the company changes over time, and it's very hard to exit. So this was designed to make it more palatable. All right, if we go to the next slide, which is talking about Section 109. This one is a little bit more relief in the same vein, right? Allows transfer of lifetime income investment vehicles between plans. So, that was also, one of the things that, was a potential issue, right? If you think about it from the participant standpoint, if I've got my annuity or whatever that I bought as an investment vehicle within my 401k, and now I want to roll it out to an IRA when I retire or terminate or whatever, how would I do that? So assuming the folks on the other end, the custodian on the other end of it can manage that contract, it can actually be transferred out in kind, really, is what this is talking about. So it's just really putting some additional relief into the whole structure. I think just from my perspective, there's been a lot of talk about annuitization. Matter of fact, there was some legislation introduced, looks like bipartisan legislation revived again in Congress. I think I just got a note on that this morning that is kind of reviving the concept of lifetime income in qualified plans, basically but legislation providing that an annuity of sorts could be a QDIA, right? Qualified Default Investment Arrangement, as opposed to the traditional lifetime income or target date type funds, right? So I don't know if that legislation will ultimately go through, but it's another step in the direction of lifetime income. And while I'm on the topic of lifetime income, the DOL came out with some rules. Was it last September or 2 Septembers ago, that basically was saying plan sponsors have to show a lifetime income calculation to participants on a participant statement. And they came out with a bunch of rules in terms of how that actually works. So that was kind of interesting, and that actually was in play for this year in 2022. That's going to end up being on a statement. And what the DOL did is they provided a safe harbor in terms of how that calculation gets done. Now, you don't necessarily have to abide by the safe harbor, but generally it would be advisable to do that to reduce the risk of how you're displaying those numbers. So there's, as we all know, a ton of talk about lifetime income in qualified plans, and there's a lot of attempts to make that happen more effectively and with less risk to the plan fiduciaries and the plan sponsors. One more slide is talking about Section 202. And again, I already talked about this to a degree. This is really the consolidated filing for GOPs, or Decent Defined Contribution Groups, as the DOL wants to call them. And I already spoke about this in terms of how that audit would work, assuming those DOL proposed rules go through in the full form. So Lizzie, if we go up one more slide, Section 403, increased penalties for failure to file. I almost want to say it seemed too good to be true, right? Because if you think about the Secure Act, and if you think about all the provisions in there that are beneficial not only to plan participants but to plan sponsors. I mean, think about the increased tax credits I mentioned earlier. Think about the fact that, we didn't touch on it yet, but the required minimum distribution age has been moved up from 70.5 to 72, and there's legislative initiatives to potentially push that to age 75. So when you're pushing off the required minimum distributions by a couple of years, that means less tax revenue for the government in the short run. So unfortunately, they kind of found a mechanism to try to make up some of that revenue loss, which is increases in fines and penalties for failure to file Form 5500. This is pretty dramatic, right? This has gone up from $25 a day to $250 a day. a factor of 10 times what it was. There's another slide that comes up at the end, and it's more of a participant penalty, and I think it's failure to file Form 5329, which is related to either not taking enough of an RMD or potentially excess contributions to IRAs, things like that. So penalties and fines have increased there too, not as dramatically, but this is kind of a way to, I think, recapture some revenue that the government would otherwise be losing in the short run due to a lot of the, can't think of the other example I gave. I can retroactively adopt a defined benefit plan or any type of qual plan for last year. That means I'm undoubtedly going to get tax deductions for last year, even though I'm adopting the plan today. Again, that's more of a short-term loss in terms of tax revenue to the government. So anyway, unfortunately, the penalties are a way to make up some of it anyway. So Lizzie, we're going to go really fast past the next slide. It's section 115. It applies to community newspaper pension funding. I would say if anybody's on the line today that wants to talk more about that, give me a call afterwards. We won't spend time on it today because it's such a tiny fraction. The next slide is non-discrimination testing for frozen DB plans. I won't spend too much time on this, but basically this is a way to negate some of the rather strict rules that were in place for certain frozen defined or partially frozen defined benefit plans, soft frozen. Potentially there could have been issues with longer serviced older employees continuing to accrue benefits. So it's a mechanism to, help transition those participants, let them continue to accrue benefits in the old plan, even though that old plan wouldn't be offered to newer employees. Lizzie, one more page. 206 is a positive impact to plan sponsors on PBGC premiums. Again, another defined benefit concept I won't spend any more time on today. And the next slide after that is section 601, which is talking about the amendments for Secure Act. So, a lot of these, we've been talking about provisions that came into play in 2020 and 21, and even really some things that come out to 2024, as well as a couple of features that are retroactive to 2018. So the question when they drafted Secure Act is, well, how quickly are we going to force plan sponsors to, adopt conforming amendments to provide for all of these new liberalizations available? And the answer is it's got to be done by the end of this year, 2022 plan year. And I'll just remind everybody, right, the CARES Act that was passed, I think, March 27th of 2021, and that was designed to alleviate some of the pressures of the pandemic that were negatively impacting plan participants, right? And that enabled plans to adopt loan features that were double the $50,000 max and allowed for in-service distributions that can actually be repaid to the plan over a period of 3 years. So, and it also allowed for loan extensions, right, back then, and additional loans due to COVID type scenarios. So, CARES Act, when they initially, and by the way, we were reading one draft of the bill after another for weeks and weeks and weeks ahead of the final date it was passed, and a whole bunch of things had changed in the 800 or 1,000 pages of that bill. But fortunately, the one thing that prevailed was the fact that any amendments, any client that afforded themselves with the flexibilities provided in the CARES Act, it gave those plan sponsors the same time frame, right, at the end of the 2022 plan year, to get those features in place and make them happen, and codify them, I should say. So Lizzie, if you go back to slide, I think probably 4 or 5 in the in the deck. So now we'll get into, and I know we're getting a little short on time. We've got about 7 or 8 minutes, 6 minutes to go here. So I'm on a slide, section 106, expanded IRA compensation. This is getting into more of the wealth management aspects, more of the features that would impact individuals as opposed to qualified plans in general. So this is an interesting one. Fellowship and stipend payments are now considered comp for IRA purposes. And this one kind of hits home. I've got my youngest daughter is entering into a PhD program where there will be a stipend, which is good, right? Which helps cover living expenses during that program. She'll be pleased to know I'm going to ask her to defer some of that money, but candidly, I'm not sure how many people are going to take advantage of this. Most people getting the stipend are using that for day-to-day living expenses. But again, it's just another example of the the Congress and the administration's promoting retirement security and giving people more ability to save money for the long term. And even if this is a very limited audience, number one, who gets stipends, number two, it's even a smaller subset of those who would actually defer some of that money or put some of that money into an IRA. At least it affords them the ability to do that. So next slide is section 116, home health care payments, a very similar concept here. Okay, my slides are slowing up again. That's okay. But again, a very similar concept. They could use some of that money for qualified plans or IRA purposes. The next slide up is the age 70 and a half. I already spoke about this, is moving to age 72. And again, that just affords more flexibility. I think this one also potentially takes pressure off of the Social Security system, right? Because, if people can delay taking these benefits to a later date, they might in fact, delay taking some Social Security, which puts some relief into that system. So we're going to go up two more slides. I know I'm moving fast here. I'm on qualified charitable distributions, QCDs. Again, some technical changes. I'm really not going to spend time on this slide. It's more for your informational purpose today. And this will all be in the final PowerPoint that you get from us as a follow-up. The next slide talks about beneficiary distribution rules, Section 401 of the Secure Act. So this really was the death knell to, I used to do a lot of speaking on the topic of intergenerational transfers of wealth. And, there was an interesting concept with that, in particular for participants who use Roth IRAs, right? Roth 401ks and Roth IRAs. Well, I should say Roth IRAs is really where it really hits home, because in theory, you could have transferred that to the kids or the grandkids, and they could have taken that money out over their lifetimes. So this really is clamping down on that and essentially confining non-spouse beneficiaries, basically kids and others, right, to taking that money over a period not to exceed 10 years. So it really isn't going to be a true lifetime intergeneration. It's still a transfer of wealth. I get that. But the point is they're making it taxable here in a much shorter time frame than was required by the prior law. Prior law, that could have been stretched out over the lifetime of the kids in many cases. Here's a 403B termination. I don't know how many of you work with 403B plans, but this is just some flexibility that was put into it. In a terminating 403B, they can distribute certain custodial accounts in kind to the participants. So I would say this is probably just one of those cleanup things in the Secure Act that did something that was more common sense than not. The next slide is Section 111. I'm pretty much going to skip this as church plans. If you want to talk in more detail, we can do that at your leisure after this presentation today. 32 is a penalty waiver. I'm sorry, my 32, Beth, you're in a different order than me. That's fine. Section 113, and this would allow for penalty-free retirement, distributions in the event of birth or adoption expenses. The only thing I'll point out here, it's a flexibility for sure for the participant level. Obviously draws on the participant's retirement account balance, which we're generally we generally don't like that. We like to keep this money for the long term. But here's the bottom line: it provides relief for families or certain people who may need that relief and want that relief. So that's kind of the good news here. I would caution you to look closely at how those rules work and how those adoption, rules in particular work. I remember going into incredible minutia, right, with the CARES Act, because there was a feature in the CARES Act that jumped on the same concept. And there are very, very precise rules in terms of the definitions of what you need to do to be able to comply with this properly. So that's just kind of the word of caution on that one. Lifetime income disclosures. This, I know we're getting, we're almost at time here. If I can just humor the group, or if you can humor me, and let me just speak about this for a half a second more. I spoke a little bit about this. The DOL came out with those rules. It's got to be on a benefit statement sometime in 2022. They came out with safe harbors and how to do it. I wrote an article over a year ago, I think it was for Plan Consultant Magazine, that kind of got into the nuts and bolts. And the biggest problem you're going to find with these disclosures, the safe harbor version, is they don't permit you to project the account balance. In other words, if I'm 25 years old and if I have $1,000 in my 401k plan, and if I'm deferring 6% of pay, you can't take my $1,000 and compound it and project it to my retirement, quote unquote, a retirement date. You can't assume I'm making future contributions, right? So basically, what the safe harbor says is take that 25-year-old with $1,000, convert the $1,000 to an annuity. What kind of lifetime income would that provide? I can't do the math off the top of my head, but it's probably like $4 a month for the rest of your life, or maybe it's $40. But these numbers are going to look dismal, right? Because there's no projection involved with it. So plan sponsors are going to have choices here, right? They can either comply with the safe harbor, or they could do. I mean, by the way, we've been, we are the record keeper. We're not always the record keeper, but if we are, we've been showing lifetime income. We take the current account, we project it at a very modest interest earnings rate over the long term. We assume they're making current contributions at the same rate of pay. I don't think we even float their comp up over time. It's just same rate of pay and current rate, and do a projection to age 65, convert that to an annuity. And the disclosure on ours, prior to the safe harbor rule, says, here's the assumption. Assuming the account grows at, I forget what it is, 5%, and assuming you make the same contributions projected to retirement, this is what it would look like. So to me, that gives you a much better, somewhat better, realistic solution than just no projection at all. So there has been some talk about getting the DOL to lighten up. Now, they have said you could show more than one example, so on and so forth. I think the approach a lot of providers will take is to use the safe harbor once a year on the benefit statement, and to have different tools available at the participant level on the participant website or on the participant's mobile app that might show a more realistic or more encouraging, anyway, end result. So I know we're at time. We did have a couple of questions, Beth. I don't think we have time for them today. We can summarize the questions we got in the follow-up for everybody. But with that, I thank everybody. I apologize for the technical glitch today. But I appreciate everybody's time. And if you have any follow-up questions, please let us know.
Right. Thank you, Rich. Everyone will get an email tomorrow with contact information that you can reach out to us with your questions. Thanks so much for joining. Have a great rest of your day.